Welcome. This is the Lifetime Cash Flow Through Real Estate Investing podcast. This is where you'll learn strategies to help you achieve lifetime financial freedom through real estate investment. Your host, Rod Cleef, has owned over 2,000 homes and apartments, and he brings experts in all aspects of real estate investment and management onto the show. Now, here's your host, Rod Cleef.
Welcome to another edition of How to Build Lifetime Cash Flow Through Real Estate Investing. I'm Rod Cleef, and I'm thrilled you're here. Before we get started, I want to remind you guys that I have written a book, and it's about multifamily real estate investing. It's about 200 pages long and literally covers everything in the business. It's kind of like a textbook. And what's interesting, actually, is that the lady we're interviewing today is a syndication attorney, and she's actually reviewing the syndication portion of that book for me to make sure it's factually accurate. And the laws change regularly. So, I know you're going to get a ton of value from her. Her name is Kim Lisa Taylor. She's a syndication attorney, and she's licensed in California and Florida, but she can do syndications all over the country. And her areas of focus is setting up entities and structures for syndications. And she loves showing her clients how to, confidently and effectively raise money for their real estate investments. And, she told me before we got started, she really enjoys working with investors and really kind of holding their hands through the process. And like I said, I'm so impressed with my communications with her that I've asked her to review my book. Now, I want to tell you guys that what we're talking about today, it may seem fairly complex and intimidating, and that's okay. I'll tell you that even if you have to listen to it more than once, and I highly recommend you do that, because if you want to be big in this business, you have to do syndications. Not be afraid of them. They're like anything else you don't understand right now. You have to, they require a learning curve. So anyway, without further ado, Kim, I am thrilled to have you on the show.
I'm really excited that you asked me to be on the show, Rod.
Awesome. Well, tell us a little bit more about you, and then we'll get right into the meat of this thing.
Okay. Well, I've been a securities attorney pretty exclusively for the last 8 years. I've been licensed as an attorney for 15 years. Most of my practice revolves around doing securities offerings for people that are raising money from private investors. I do a lot of teaching and speaking, and I, too, am writing a book. Mine's not quite as far along as yours. So.
Yeah, I'll tell you, the whole book thing has just been a lot more involved than I thought it was. And I know there are a lot of people waiting for it right now. I mean, it's a huge number, and I just am really anxious to get it done as soon as I can. And that's not a push on you, because it's actually the final editing is going to take longer than the work you're doing on it. But yeah, so now you know. Welcome to the club.
That's right. It does take a long time. It does take a long time. Well, so my practice, our mantra is that we help entrepreneurs create successful investment companies. So we provide services that are a little bit more than you're going to get from a typical law firm, because we like to delve into the corporate structure, give you advice and guidance about marketing and how to go out and find those investors, how to position yourself so that your offering will be successful.
Wow. Well, I didn't even know that. That's really very comprehensive. So we're going to dig into that a little bit. But let's start very basic. What's a security? Why do they need to do this?
Well, securities laws arose out of the Securities Act of 1933 in the wake of the Great Depression. And at the time, it was felt that a lot of people had been kind of defrauded of their money by a bunch of snake oil salesmen, and there were no real ramifications because somebody who was defrauding people of their money in Alabama could hop state lines and go into Florida and do it again, and there was no overarching law that could reach out to them across the country. So that was the 1933 Securities Act. And it did a number of things. It made it illegal to commit fraud using any form of interstate commerce, including mail and wire and phone and internet and all of those things that we're now using. And it required that if you were going to sell people something in exchange for their money, that you had to provide certain disclosures, give them all the material facts, explain all the risks to them, and that you would then be able to go out and offer these things to people as long as you followed a certain set of rules. So that's really what securities laws are, is they set the framework and the set of rules that people have to follow if they want to raise money from other people. And the securities themselves it's really the piece of paper or whatever it is you're giving someone in exchange for their money.
Okay, and that can even be like a promissory note.
Could be a promissory note.
Right.
Yes.
So this involves debt investors as well as equity investors.
Absolutely. The Securities Act defined what securities were, and there's two things that apply to real estate investors. One of them, the very first thing in every definition under federal or state law of a security is a note. So promissory notes are securities. And the second thing are called investment contracts. And there's kind of a technical definition for that. It's an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. And so that really means when you're looking for passive investors versus somebody who's going to be actively involved with you, you're looking for someone to give you some money. You're going to take control of that money. You're going to go out and do something with it. They're relying on you to use your experience to make a profit for them, and then to send them a return on that money, and then eventually to provide their money back.
Right.
So that really is the investment contract.
And so on the flip side, if you're out there and you and your buddy are both going in on a deal and you're both working the deal, then that's a joint venture and does not apply in securities laws. If the partners that are involved in the deal are all active participants and decision makers, then it doesn't fall into these guidelines. It's when you go out there and pull money from somebody who's not going to play a role in the investment, they are just looking for a return, that's when you're needed.
That's when you really got to delve into the securities laws. And so the securities laws say if you're selling securities, then you need to either register those securities, which means you need to get them pre-approved by a regulatory agency, like an IPO that Google or Facebook did. They went through this whole regulatory scrutiny before the SEC said, okay, you can sell these to the public. So that's the registration process.
Right.
If you don't have time, which most real estate investors don't have time to go through that whole registration process, then you're going to need to qualify for an exemption from registration. And the exemptions are defined either under federal law, which most people use, or some of them are defined under state law if you're going to be doing activities all within one single state.
Yeah, and we're not going to talk about the state because it's just so unusual. We're just going to focus on federal right now. So let's talk about the two most common exceptions that you utilize in preparing syndications. I believe 506B and 506C. Can you talk about those?
Absolutely. So those are two of the exemptions that are the two that are most commonly used for real estate offerings, and those are the ones that I write all the time.
Right.
So the 506B is kind of the original rule, and that says that you can raise an unlimited amount of money from an unlimited number of accredited investors and up to 35 sophisticated investors, but you can't do it through any form of general advertising or solicitation. And the way to prove that is to show that you had a pre-existing relationship with those investors before you made offers to invest.
Okay, so let me stop you there for 1 second. Let's dig a little deeper on what you just said. So I know there are three types of investors. Can you talk about what they are, starting with accredited?
So accredited investors are people that have over $1 million net worth exclusive of any equity in their primary residence, or if they're single, they make over $200,000 a year, or if they're married, they make over $300,000 a year.
Right. So that's an accredited investor, guys. So now what's a sophisticated investor?
Someone who is not accredited but has other business knowledge or education or investing experience that makes them more than just a lay person.
Okay.
So they've got some savvy.
So they know a little bit about business. I suppose that's got some subjective nature to it, but then basically everybody else is the third group, correct?
The other are the unaccredited group. So they're unaccredited, they're not sophisticated. Just want to touch back on the sophisticated for a minute. Okay. Your listeners or people who have gone through the steps of educating themselves on some real estate investing techniques and things that they could do with their in retirement dollars or something like that. they might fall into that sophisticated category.
Okay. All right. So those are the three types of investors. And this is under Regulation D, correct? Reg D.
Yes.
Okay.
This arose out of the 1933 Securities Act, and so this is a further regulation issued by the Securities and Exchange Commission.
Okay.
So 506B is the original rule.
Let's go back to the 506B and talk about established relationship and advertising versus not. Well, actually, as it relates to 506B, let's talk about the three-touch rule for a minute.
Sure. Okay. So I mentioned when I was describing the definition for 506B that you have to have you should be able to demonstrate a pre-existing relationship in order to prove that you didn't violate the prohibition against any general advertising or solicitation to the public. Right. So the SEC has gone at length into a series of what they call no action letters, where people have asked this question, well, what if I did this or what if I did that? And the SEC will kind of write an opinion on, well, if you did it just this way, it might be okay or that. And what the rules have boiled down to out of those no action letters is that you have to establish a quality relationship with somebody. It's not necessarily a number of touches or an amount of time. It's really that you have to, the quality of the relationship has to be such that you, one, understand their financial circumstances so you know before you start making offers to them whether they're accredited or sophisticated, and that you understand whether what you're offering them is suitable for their investment portfolio.
Guys, one thing I want you to pick up on all this is when you're out there looking for money and talking to people, it's more about finding out about them than it is, or as important as you telling them about you. You need to find out what their investment criteria is. How soon do they want their, if they invest in something, how soon do they need the money back? Do they need it for a future event? Are they in for the long haul for cash flow? These are the kinds of questions, along with, of course, finding out if they're accredited through finding out more detailed income information or asset information that will help you in making sure that whoever you're talking to actually even is the right fit for your investment. So anyway, thank you for that on the developing the relationship. Let's go move on to 506B C then, please. 506C.
That's right. Okay, perfect. So 506C is just really an offshoot of 506B. And when the SEC passed this rule, it basically said, all right, we're going to relax the prohibition on any kind of general solicitation or advertising as long as the only people you allow to invest in your deal are verified accredited investors. So in 506B, you were able to give somebody a pre-qualification form with just, a couple of the definition of accredited and sophisticated, let them check a box, how they met, whether they met that definition. And that was good enough. So they could self-certify. But now if you want to do a 506C offering and you want to be able to advertise it, the person who is selling the securities, called the issuer of the securities, has to be reasonably assured that that investor is accredited at the time they make that investment.
Okay, so that's the typical vagueness that the federal government will throw into laws. What does reasonably assured, how's that been interpreted so far? Have you read on that?
Well, they gave some examples and said, okay, well, if somebody could provide a letter, if an investor could provide a letter from someone with the license, so they cited specifically an attorney, a registered investment advisor, or their own CPA that says, yes, we've looked at their financials within the last 90 days and they are accredited. If you could get that letter, then that would give you reasonable assurance. But they did say that's not the only way you could do it. You could look at the issuer of the securities could look at the information themselves. They could look at the financials. They could look at that. Or there are some third-party companies that have arisen in the wake of this law that will do it for them.
Oh, wow. So there's some contractors that you can develop a relationship with that obviously for a fee, they will contact your investor and do a quick analysis and do it on your behalf.
That's right.
Okay. So let me ask you this. Let me ask you a hypothetical. So you can you can do a 506C and advertise it as long as you only take accredited investors. So let me give you a hypothetical. Let's say I create a 506C for a property, and I decide, you know what, I'm going to advertise this thing on the radio, and of course I'm going to have I don't know what the disclosure requirements are as it relates to the actual marketing piece, or the advertising medium. We'll talk about that in a second. But if I get calls from non-accredited investors, correct me if I'm wrong, I could still develop a relationship for a further future 506B offering, correct?
That's right. But we don't think that you can run them concurrently.
Okay.
Because you wouldn't be able to demonstrate in your 506B offering that you didn't meet them through any form of general advertising or solicitation. So you could potentially do a 506C offering, meet people that are not accredited, that aren't qualified for that offering, develop that relationship with them, and tell them that, I can't offer you anything right now, but perhaps in the future when I go to do an offering that allows non-accredited investors in it, then I will give you a call.
You can't do two at the same time, but you could certainly do one later and build your investor database, for when you do one down the road.
Absolutely.
Okay, so guys, just to recap so that you got that. On a 506C, you have, and I'm just going to be redundant here just to make sure you got it because it's a little bit complex, but on a 506C, you have to take accredited investors into that transaction. But you can advertise, which is huge. There's so many mediums that don't even cost money, like social media and things of that nature, that you can, advertise a deal. And then if they're not accredited, you just start developing a relationship with them for future deals. Now let's back up for a second and talk about, in a 506C, what are the requirements for advertising in that exemption?
There's no real requirements as long as everything you say is truthful. And that's important to have a securities attorney review your ads before you offer them, because you could say something inadvertent. Like, there's buzzwords that are just kind of
red flags. Okay.
Red flags, right. Like guaranteed returns, or, a lot of people will say we're looking for joint venture opportunities, and they're really not. They're really looking for passive investors. We just need to make sure that all the things that you're saying are 100% accurate and truthful.
So just, you just want to have Kim look at the advertising before it goes out. But guys, this is a real opportunity with this 506C. I just have to tell you, it's much, much easier than we've had to do it in the past. Let's talk for a second about blind pools versus property-specific offerings. What are your thoughts on that?
I write a lot of blind pools for clients. It depends on what you're buying. So, and it also depends.
Can you describe what a blind pool is for the audience?
Sure. Okay. So a specified offering, that's where you have something under contract right now, say an apartment complex, and you want to close on that within 90 or 120 days. And you need to raise a finite amount of money. You're going to go out and get some bank financing, and then you're going to raise the difference for the down payment, the closing costs, the due diligence costs, plus maybe an acquisition fee for yourself. You would raise all of that from private investors, then you get to the closing table and you use that money. That's a specified offering. Right. All right. A blind pool is kind of the opposite of that. That's where you have a concept or an idea, a business plan. I actually call it an investment summary, where you say, hey, we're going to go out and buy multiple properties. We haven't identified any of them yet, but we do have experience with these kinds of properties. We've done a number of them in the past. And so we're doing the same thing we did before. We're just going to raise the money in advance so that we can take advantage of these faster opportunities. Okay.
Well, what I will say, guys, for those of you that just heard that are thinking, hey, I'm going to do a blind pool because then I'll have the money when I find a deal. Don't do that unless you have the track record, because, correct me if I'm wrong, Kim, blind pools are more difficult to obtain money for because you don't have specific pro forma information to show on a specific property unless you've got, like you said, historical information and the likelihood of finding similar deals in the future that you can prove.
That's exactly right. You will have a very hard time raising money in a blind pool unless you have a specific track record. Now, If you don't have that track record yourself, how could you get it? Well, you could leverage your experience with somebody else who has that kind of experience.
Very good. Thank you for that. I should have suggested that myself. Absolutely. You find a sponsor, you find partners that have taken down that caliber of property, and you're reasonably assured that you can find similar property like that, then you can do it. I'm really glad you brought that up. Okay, so let's talk about the typical sequence, of a syndication from your viewpoint, and in your opinion, when in the process the syndicator should engage you. Can you speak to the syntax, the sequence, the timeline?
Sure.
Okay.
When you've got the idea of what you want to do, it's a really good time to begin your initial consultation with Securities Counsel and identify who you connect with, who you feel is going to really help nurture you through the process and help you get the result that you want.
You're talking about you now.
Well, of course.
Okay. All right. So basically what she's saying, guys, is develop a relationship with an attorney early on. And I recommend Kim for sure. But okay, got it. I was want to just clear that up. Okay.
Thank you. So if you have a property under contract, so if you're you're doing a specified offering with something you have under contract, then you would want to, I always tell my clients that you should hire me at the point that you have a signed purchase and sale agreement, not an LOI, signed purchase and sale agreement. Someone has physically been to the property, someone on your team, and you've reviewed the financials from the seller, so the last 2 years historical financials. With those things in hand, then you're probably 85-90% assured that you're going to close on that deal. And anything else that you might find during the rest of your due diligence would become deal negotiation points with the seller.
Okay, so let me ask you this, though. Everybody's thinking, okay, yeah, but then I'm only going to have so many days to raise the money. What can they have done ahead of time to get commitments from investors, even though the syndication documents haven't been initiated yet?
There's not a lot they can do to get commitments, but they can certainly develop a database of prospective investors. And so you do that through networking events. Face-to-face networking events is absolutely the most effective way to do that. You can do that in your local community by joining your Chamber of Commerce and philanthropic organizations, or a nationwide event.
Let's say you've only got a 30-day due diligence. How long does it take you to prepare on your end?
We should be doing the documents at the same time you're doing the rest of your due diligence so that the two of them end concurrently.
I see. Okay.
So it takes 2 to 4 weeks to prepare a set of offering documents. The first set that you ever see is going to take longer because we're generating about 140 pages of legal documents, and you have to review it, and you're responsible for making sure that every statement in the documents that we've written is 100% correct because the liability rests with the client.
Okay. Well, that would, you don't see the discomfort there if you're under a 30-day due diligence and you're putting your investors together maybe on your first deal and, you're just locking them up literally days before the money goes hard. That's common? That's not uncommon? That's okay?
Well, you will do a property information package on a specified offering where you're going to show the projections of how the property is going to do, what kind of returns it's going to yield, and other just general physical information about the property. You will do that, and we like to review that first so that you can start showing that to your investors while we're generating the rest of the documents. And that way they're getting their money ready, knowing that they're going to see the full offering package as soon as it's complete, and they cannot make their investment until that time.
Okay, got it. Okay, that was the missing piece there. Okay, so that's you do that first. You do the offering memorandum. You review that and make sure it's factually correct, and then they can whet the appetite and get the investors excited, and then do the final offering documents once you've got them done. And you're obviously on top of the time deadlines and everything else, I'm sure, as you're doing these deals, correct?
Yes. And so we'll put together the offering package. Once that's complete, you can go out and start accepting funds from investors. And then the rest of the time that you have on your due diligence and your escrow period before closing would be time you would spend raising the money and then also generating any other documents that the lender might require of you.
Right, because you'll be dealing with the loan as well, most typically. How often do you do syndication where it's all equity?
Never on specified offerings because it's usually too hard to get a good enough return without leverage to make it viable for a syndication. You really need to have somewhere around a 12% cash on cash return, 10% minimum before you're going to be able to have a lucrative enough deal to pay your investors something that they're willing to accept and to give yourself enough compensation to be worth it for you to do the deal.
Okay. No, that makes good sense. That's the power of leverage. Okay. What haven't I asked you, Kim?
Well, just to back up on that last question, if you're doing a blind pool, so say a single family fix and flip fund or a single family buy and hold fund, those are very typically all cash deals because there's a lot more cash to be made on that. But there could even be some leverage component within that. If you're doing a buy and hold fund, you might buy with cash, and then once it's the property's repaired and it's rented, then maybe you'd go out and get some leverage on that to boost that return for your investors. Okay.
What else haven't I asked you about this process that can add value to new investors and people that own multifamily but haven't done a syndication yet?
My most successful repeat clients that have done multiple deals have had some coach. Some coaching program or guidance that they're getting from an experienced third party that can help them achieve their goals. So, I have a coach for my law firm. I recommend that everybody should have a coach.
Yeah.
It's just a really good idea.
Yeah, I'm actually. That's funny you say that because I'm actually going to start doing coaching. I've thought about it, and this will be the first time any of my listeners have heard this. I take free 30-minute calls from them, but from hundreds of people I've taken. But I've realized there's a much bigger need, so I've decided I'm going to start doing that in the very near future. But I absolutely agree. I've had a coach for 20 years. Different coaches, for different things. Personal coach, business coaches. And I talk about the value of mentors and those coaching relationships on the show all the time, and you guys have heard me say it many, many times. Well, listen, Kim, you have been a lot of fun and very, very knowledgeable. I appreciate your valuable time, and I look forward to doing business with you myself. So, thank you so much. And is there any other last little bit of advice you might give an aspiring investor?
Don't give up. Put yourself in the company of other people that are investment minded, whether that's through your local real estate investment clubs or if you're attending national events where you're getting training on a specific asset class. Just keep going to those events, and that stuff does rub off on you, and you do get inspiration by going to those places. I highly recommend it.
I just realized there was one thing we forgot to expand on, and I don't want to forget about that. What besides going and networking to find investors, any other little tips there on finding investors from an SEC attorney?
It's really all about relationships. You're not going to send out buy an accredited investor list and send out 10-cent postcards and get $100,000 checks in the mail. And if you do, you better vet that money very carefully and make sure you know where it came from.
Okay.
So you've really just got to meet people. And even though you can advertise, all that's going to do is allow you to increase your database and increase the number of people that you can develop relationships with. So even though you're not required to have that pre-existing relationship, you're going to be getting into a business relationship with someone for the next 3 to 7 years. You want to make sure that this person is a good fit for you as much as you're a good fit for them.
Yeah, now absolutely. You develop that relationship. You ask lots of questions, and you go have coffee, you go have lunch, and you're communicating with them regularly. Maybe you're sending them information about a market area that you like. There's lots of ways to develop and nurture those relationships. Well, Kim, thank you so much. I really appreciate your valuable time.
Well, thank you, Rod. If you'd like to reach me, you can contact me at syndicationattorneys.com, or you can call me at 904-584-5600. 4055.
Thank you for listening to the Lifetime Cash Flow Through Real Estate Investing podcast. If you've enjoyed the show, please subscribe and then take a moment to visit iTunes and leave a 5-star rating and review. For more resources to connect with us further, please visit our website at lifetimecashflowpodcast.com. Tune in next week for our next show.